Law of Contract, Indemnity and Guarantee. 1. Contract of Indemnity. Definition, Section 124, Indian Contract Act, 1872. A contract of indemnity is a contract by which one party promises to save the other from loss caused either by the conduct of the promiser himself or by the conduct of any other person. The party who gives the promise is called the indemnifier, and the party whose loss is to be made good is called the indemnified, or promisee. Example, A says to B, "Go and buy goods from C on credit. If C sues you for non-payment, I will compensate you." Here, A is the indemnifier and B is the indemnified. If C sues B, A must pay. 2. Rights of the Indemnity Holder, Section 125. When the indemnity holder, promisee, has acted within the scope of his authority, he is entitled to recover from the indemnifier, A, all damages that he was compelled to pay in any suit in respect of any matter to which the contract of indemnity applies. Example, B is sued by C and the court orders B to pay a $50,000. A must reimburse B that entire amount. B, all costs that he was compelled to pay in bringing or defending such a suit, provided he did not act contrary to the indemnifier's instructions. Example, B spends Rs $10,000 on lawyer's fees defending himself. A must pay this too. C, all sums that he may have paid under the terms of any compromise of any such suit, provided the compromise was not contrary to the indemnifier's instructions and was one which it was prudent to make. Example, B settles with C for Rs 30,000 out of court. If the compromise was reasonable, A must pay Rs 30,000. 3. Liability of the Indemnifier. The Indian Contract Act does not explicitly state when the indemnifier's liability begins, but courts have interpreted it as follows. The indemnifier becomes liable as soon as the indemnified suffers actual loss, meaning the indemnified need not actually pay the loss out of pocket first. If the indemnified is absolutely liable to pay, the indemnifier can be asked to save him from that liability even before actual payment. This position was settled in the case of Gajanan Moreshwar vs. Moreshwar Madan, 1942, Bombay HC, where the court held that equity demands the indemnifier relieve the indemnified as soon as an absolute liability arises. Example, A promises to indemnify B against any claim by C. C files a suit and the court passes a decree against B. B does not have to wait until he actually pays C. The moment the decree is passed, B can demand A step in and pay on his behalf. 4. Contract of Guarantee Definition, Section 126, Indian Contract Act, 1872. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. There are 3 parties involved: principal debtor, the person who takes the loan or incurs the primary liability; creditor, the person to whom the guarantee is given; surety, guarantor, the person who gives the guarantee. There are always 3 contracts operating simultaneously,